Hello everyone, Brighton Tejachi is my name, and for today we are going to talk about the contract of sales of goods and supply of services. It is governed by the Contract of Sales of Goods and Supply of Services Act. So this is our YouTube channel. It is called The Legal Forum, and for this we shall be making a lot of videos explaining the law, the topics, the course units in law school, so that very many other students outside there, they can come out and get entertained. They read, they watch. By the end of it all, they get the concept. So the legal forum is now tuned on. So thank you for watching. Thank you for listening. Brighton is my name. So, a contract of sales of goods and supply of services, as it is governed by the Contract of Sales and Supply of Services Act. For it, it is explaining on how someone, so-called a buyer, comes in, buys goods, then he pays in so-called consideration. So you come, you buy, or I sell, you pay me, or I pay you, and it is done. That is the contract made. So by the end of this session, I'm very sure that you'll be confident with the introduction, the rules, the purpose of the law in it, and how to formulate the same contract, and we shall call it a day. So as we have said, the contract of sales, it is like any other contracts, which means that you come, you buy, you take it after paying in so-called price. So it means it also have its element as the other contract. As we have said, it does not differ from the contract law which you studied, which means it also have these certain things: offer, acceptance, and consideration. So the case there, what you have to put in mind, and the case which you can read and get to know very much more about the elements of the contract, is the Carbolic Smoke Ball. The Carbolic Smoke Ball case. So that case is very good for you to learn and understand how an offer, acceptance, and consideration works. So which means that the consideration, there must be payment, the benefit after exchanging from good or services. So which means for you to enter into a contract, there must be what we call capacity under section 19 and 20. So which means that someone should obtain the capacity to enter into a contract, as it is said that a person below the age of 18 cannot enter into a contract, but to certain conditions where that person can be privileged, or that person can be given a chance to enter into a contract. So you have to put that in mind. So which means a minor also, to that exception, can enter into a contract, which means it can still stand. The contract can still stand. You have to put in mind that they are talking about where there are necessities whereby someone is going to buy like stuffs like food, medical treatment, buying like books. So that person, if he or she is not above 18, he can go ahead and contract or buy something, a contract of sales. But again, they are telling us that that person should be of a sound mind. So you have to put in mind that. So in the case Pinnock versus Barnett, they explained how a minor can contract. In this case, we saw that that minor was going to buy a book. So which means, like, if I want a book and I'm like 10 years, I can go ahead and buy that book because it is a necessity. But to some extent, when you're buying things like alcohol, you will find it is written restrictly, not for people under the age of 18, which means to that person, a minor, cannot enter into that contract. Put in mind that. So when you look at section 2, clause 1, that is the supply of goods, Sales of Goods and Supply of Services Act. You can call it SOGA. It will be the good word there to talk, SOGA. So section 2 clause 1 of SOGA, it talks about sale of good, which means that it is an agreement to transfer the good or property to the buyer for money consideration called price. As we have said, yes, that person will only and will transfer the good to the buyer, and the expectation is to receive money. So you have to put mind that. So a contract of supply of services, it means where someone agrees to carry out a service, whether goods are to be transferred in a way called hire. So it is a good example. It's where you find someone is called to come like install like bulbs in the house. So when you come and you install that service in the house, then that is supply of services. However much it has that element of a good. So you have to put mind in that. It's where we find there are goods, but in that essence, they are in the same situation that they are in, say, supply. You supply goods. So you buy items, you supply them. Same applies to the hotel. The hotel, they go ahead, they cook food, then they serve the customer. That is the supplying of service. You supply customers food. So there are certain elements of a good, which means that in this essence, when you are giving out a good, or when you're selling your good, these are the key things that must be so-called elements. There must be a buyer and a seller, which means there must be those two people, a buyer and a seller, which means when I'm selling, then there must be someone who is buying. So there is what we call the transfer of property or the transfer of ownership. So this means that someone who is selling must have ownership. You find me selling something. I'm selling a car. Then it must be mine. I must be the one who is selling something. It is mine. It is not for another person. However much there are some exceptions, but to this essence, it says that you, to sell things, it must be yours, or you must have ownership over the same. So there must be a good, and there must be a price. Yes, there must be a good and there must be a price. And another thing that you have to put in mind is that transfer of possession does not suffer, does not sufficient. Transfer of possession does not sufficient. This means that when you're transferring the possession, should not sufficient. An example is like, I've brought my phone and I've said, you be with my phone for some time, I will come back and take it. So when I come back and I'm saying that you give me my phone, when you're transferring a phone from you to me, it does not mean that you have to ask for something, that because you're giving me back, or you're transferring something from your hands to mine, so you should not ask me money because it's already mine. So you have to put in mind that. So let's go and look at types of goods. So section 1, section 1, it defines a good as anything movable or anything growing as part of the land. So a good which form the subject of a contract of sale, be either existing or future good. So in this essence, we are saying that a good should be a future or existing good. What does it mean? That a good should be, we should enter into that contract knowing that the good will be made after some time. Take an example. I may say that you give me, I want 10 chairs in 10 days. Then you start to manufacture. That is a future good. But when I come and I say, that car, I need that car, UAK, like 893K. So that is existing good. It's there, I'm seeing it. So that is existing good. So when we look at section 6.1, it analyzes types of goods. It talks about the existing goods, that goods which are tangible. It also talks about the specific goods. It talks about the ascertained and unascertained goods. So those are some of types of goods that you have to look into, you have to read through. So when you look at specific goods, these are goods that are identified and agreed on a contract. We have agreed that I want a car, I want a Corona car, UAK. It's black. That is specific. You can see it is specific. But when you bring a blue, when you bring a white one, I will not take it because I have specified in mine. If the buyer selects a red type, then it should be red. You get? So for an ascertained goods, these are goods which you can identify them. Take an example. When I come, I say I want 10 bags of posho, which means I have an interest and I want those kind of kilograms. I want in 10 kilogram, each bag 10 kilogram. So those are certain goods. So future goods, as we have said, you may find that I come, I say, you make for me furniture. You make for me furniture. They are not there, but we have agreed for you to come out and make them. So that is future goods. We have what we call, we have several goods, and those are goods which are attached to land. And section 6 tells us that where goods are attached to the land, or they form part of the land, but again they can still be served. Take an example. I come, I find the tree, it is attached to the land. I say you can give me, you can make for me 100 timbers. Then you go ahead, you cut it, you do your things, you get 100 timber out of it. Then it means those are goods attached to the land. So here, as we have said, who can make a contract? who can make a contract. As we've said, we have talked about capacity. We have talked about capacity. That a person who is aged 18 is the person who is allowed to contract, but the exception says where the good is a necessity, then the other person can also go ahead and enter into that contract. So that is the person who can enter into a contract. But we again say that over the same, there must be terms to be followed. That's why we come out and say implied conditions or implied terms and express terms. And you know, in this world that we don't commonly do things basing on the doctrines. We do things basing on things like fairness and equity. So sometimes I may come, I say I want a pen. There is no need that I will say that let it be underwriting. So these things, but when you're drafting a bigger contract, you're buying a car, then you have to make sure that you have to know the ownership. So in those things, then you have to make sure that when you're entering into that contract, then you have to be aware of anything you're going to do. You have to be aware of the person who owns it. Is it the right person? Because that person may sell things which are not his. Then you find yourself, you are in fault. So thank you very much, and thank you for watching. Thank you for listening. I salute you all.